You've heard me talk about taxes before, and, well, here I go again. Have you ever seen the movie The Invisible Man? There have been several versions because the concept works. It's the unknown that sometimes is the most terrifying. The real estate equivalent of this horror story is the invisible lien, a tax lien imposed against property under Section 12-55-124 of the South Carolina Code of Laws. As your settlement agent, it is our job to ensure that the lien doesn't jump from the horror story to headline. The statute says that in case of a transfer of a majority of assets of a business other than cash, any tax generated by the business which was due on or before the date of the transfer constitutes a lien against the assets until the taxes are paid. That means that even if a tax bill hasn't been issued, the seller's taxes would still be due and now could be collected from the buyer. So, there are two questions your closing attorney should ask every time the seller is selling property that was not their primary residence. Is the property a business asset? And if so, does the asset represent a majority of the assets belonging to the seller? In determining whether what is being sold is a majority, we must look at the fair market value of the seller's total portfolio and not just the number of assets transferred. In other words, if the seller LLC has 3 other rental properties worth an aggregate of $300,000, and the one the seller is selling in our transaction is worth $500,000, then this one property is the majority. In a nutshell, if an LLC or a corporation has not paid its taxes and then sells real estate, those unpaid taxes are a lien against the real estate. The buyer could end up paying the seller's taxes. The lien is invisible because there's no website or lien book for the South Carolina Department of Revenue that a title search can access to find the lien. The lien arises when a business that has not filed or paid taxes sells more than a majority of its assets. So how do we protect buyers from this monster? First, we will ask the seller if the property being sold is a business asset. Usually, the answer is yes. We will also ask the seller if the property being sold is less than a majority of their assets. If their answer is yes, then we can move forward with closing. If the answer is no, then we have to obtain a certificate of tax compliance from the South Carolina Department of Revenue. This certificate shows if the taxpayer has paid his taxes. Why don't we just get that every time? The Department of Revenue estimates the turnaround time for tax compliance certificate can take up to 2 weeks, and it requires the seller to execute an affidavit and submit payment for the letter. In other words, it can create a significant delay to closing. So, what can agents or sellers do to help avoid this delay and to ensure that the buyer doesn't have to foot the seller's tax bill? At closing, your settlement agent should have the seller execute a Transferor Affidavit. The purpose of this affidavit is to protect the buyer who is either not receiving business assets or is receiving less than a majority of the seller's assets from a tax lien that might be placed on the assets transferred if the transferor does not file all the applicable returns or pay all of its South Carolina tax liabilities. The Transferor Affidavit is valid for 30 days from the date it's signed by the seller. In other words, if the transferee obtains a valid Transferor Affidavit and the transfer takes place during this 30-day period, then the Department of Revenue will not assert that a lien was placed against the assets that are now in the hands of the transferee. And, if applicable, the department will not refuse to issue a license to the transferee, and it will not revoke a license based on this invisible lien code section. If you have any questions about this topic or any other real estate matters, please do not hesitate to reach out. We look forward to meeting you.